Good afternoon, good evening, and thank you so much for joining us today here. My name is Dana Beldemann. I head the IP Center of the Bucerius Law School, and I'm very pleased to welcome you here to this lecture of the Bucerius Law School's interdisciplinary program, which we would like to thank the law school for. There's no representative of the law school management, but we are very grateful to be able to be here. So we are extremely honored to have with us an outstanding speaker. Professor Shubha Ghosh has been a visiting scholar at the law school for the past few months. As part of an interdisciplinary program he's carrying out together with the IP Center. Professor Ghosh is the Crandall Melvin Professor of Law at Syracuse University in New York State. He's also the director of the Syracuse Intellectual Property Law Institute. He has received a JD with distinction from Stanford Law School, a PhD in economics from the University of Michigan, and a BA from Amherst College. So Professor Ghosh has an impressive breadth as well as depth of knowledge, and he transitions with ease among disciplines from economics to IP to business law to pharmaceutics and others. Truly impressive. And of course, he has published extensively on numerous areas of IP law, competition law, antitrust law and policy, technology transfer, and so on. And not surprisingly, his speech today on lawyering fast and lawyering slow involves an erudite and thoughtful approach to the relation between the legal profession and legal technology. So this is not about the state of artificial intelligence, nor is it about how lawyers will soon be replaced by robots. We do not think that. But it's a neutral assessment of how the advance of technology will play out in light of three core factors, which are the failure of lawyering, legal technology, and the rules governing the legal profession. And as you may have guessed from the title, Professor Ghosh draws on the framework developed by Nobel Prize winner Daniel Kahneman in his book, Thinking Fast, Thinking Slow. So much for the presentation. I will now turn it over to Professor Ghosh. Just before that, a couple of logistics. We'll talk about an hour or maybe less, including question and answers. And after that, we would like to invite you to continue the discussion over a glass of wine just outside this room. And now, Professor Ghosh. Thank you.
Well, thank you. Thank you for attending on a rainy day. I guess there's not much less to do on such a day, but I think the opera had a good program, and I know there's the India Film Festival playing at the Metropolitan Kino. I was able to see a movie there last night. I recommend it highly if people are interested. There are other German movies are playing as well. But, go after. But thank you again. It's been an absolute pleasure to have been visiting at Bucerius and in Hamburg the last few months. I want to extend my thanks to Professor Beldemann and the IP Center and to Professor Schaefer at the Center for Law and Economics, who has also supported my visit here. Professor Schaefer is a friend and also a Facebook friend, and unfortunately I think he's now behind the great firewall of China because he's teaching in Shanghai at this point. So I wish him well. I post about this talk on Facebook with fondness largely for his benefit, and unfortunately he can't see it at this point. But anyway, thank you so much. I've really enjoyed it. I've had many good conversations, but I should thank Dirk as well, Dirk Hartung, and many of the professionals in the legal community in Hamburg, as well as contacts at the Center for Legal Professions. So it's been such a really rich environment, and I hope in the next hour or so, and with the questions and answers, I can sort of pay back what I've learned in the last couple of months and the opportunity to put together a lot of thought on this issue of legal tech and the legal profession. My primary writing, as Professor Beldemann has mentioned, is in intellectual property, and as I was approaching this topic of legal tech, I was thinking about it from the perspective of intellectual property, and a lot of people have written about this. Whether a robot can get a patent. Similar to a question about whether a monkey can get a patent. No, in the U.S. Perhaps in the future, the robot will pave the way for monkeys to get patents and copyrights as well. But I found that it's an interesting topic, but it got me more thinking about what exactly is it that intellectual property lawyers do, and then what lawyers do more broadly, and how this plays in and intersects with legal tech. And so I took that as the topic for the research project, is to really kind of make a case for how legal tech will enhance and change the legal profession, and what are some of the limits within the legal profession. Professor Beldiman mentions in the draft paper that we've been working on together about lawyer failure, and I thought it would be too depressing to talk about failure. And so I used the word gap. I don't know if I might keep failure in the actual paper, if that seems more exciting or something. But it may be useful to think about gaps if that's more appealing at this late hour for a presentation. So, as Professor Beldiman mentioned, I'm going to tie this into some work in cognitive psychology, and I'll hopefully talk with that roughly maybe halfway through. But I wanted to just give you some sense of where legal tech is, as I understand it, and then tie it into what gaps it might fill in the legal profession. And so what makes this really interesting for me, like with any project, is that there are lots of moving pieces. It's really hard to talk about one part without talking about something else. So even if in our conversation we had a few nights ago in preparation for tonight, we started talking about the legal profession, just what lawyers do. Then it turned into a question about how lawyers get regulated, and whether legal rules are too protectionist. And then when you get into protectionism, you get into what is the market for lawyers, how is that market for legal services apply, and then we talk about legal tech. It all sort of fits together in a way that's very hard to find a good fulcrum. And so it's important to keep that in mind. I'm going to start with legal tech as sort of the fulcrum to see where that is, just sort of maybe inductively thinking about where things have developed, and then move from there to think a little bit more about legal practice, and then think about legal organizations, and then finally end with legal reform. And so this is roughly the roadmap, that I'm going to follow in the next 45 minutes or so, starting off with the legal tech realities, and then going into the lawyer and organizational gap, rather than failure, lawyer and organizational gap that legal tech may be filling, and then finally talking about legal reform, what are the types of legal reforms that are happening, as I've learned in the last couple of months in Germany, but it's certainly moving at a fairly fast rate in the United States, as well as in other jurisdictions. And so this is kind of a point. And I should have emphasized that I view this time together as more of a learning experience, because I look forward to your questions and your thoughts. And feel free if at any point you think that I've not made my case, or I have not really, I've left too many gaps in my logic or thinking, or I've ignored something altogether, which is very likely that I've done, please fill in those gaps, my own gaps, during the Q&A. So let's talk about the roadmap, starting with the legal tech realities. And so I'll use the definition of legal tech that goes to from Marcus Hartland's book, and I think he traces it to various sources online, and use of technology and software to provide legal services. So we're talking about technology, again, is sort of an overused term, but here we're talking about technology maybe meaning hardware to work with software, or it could mean lots of different things that are software-based or overlap with software, but really maybe having their realm in something else, maybe like mathematics or cognitive theory, whatever it might be. But we're thinking about these as ways to provide legal services. There might be ways in which they substitute for traditional forms of providing legal services, which would be attorneys, or there could be ways in which we think about enhancing them. But this is what we're thinking about as legal tech, as opposed to other types of tech. And also we're thinking about tech largely in this kind of interface between software and hardware as well. That's important to mention. And so, as Professor Beldiman mentioned, I do the Center for IP. We do actually a lot of technology transfer work too, or try to, at the university. I mean, upstate New York is really, as the state of New York more broadly, is trying to use technology transfer in different areas as a tool for economic development. That's obviously a strategy in many parts of the United States, many parts of the world. and so we struggle with the notion of technology. I take a very maybe blasé notion of technology. What isn't technology? At some point, I think there's a tendency to view technology as whatever might be new, that might be right, but it ignores the fact that we're always using technology. And I think about taking the elevator here and how we take elevators for granted. But of course, elevators, as you have the transmission of the elevator or the lift, throughout the world, it actually did put many people out of jobs. I have a former colleague actually in the Bay Area as well. I think Dana knows him. I'll mention this later. One thing we don't know about, you may not know about him, is he was at one point an elevator operator, believe it or not. He's not that much older than me, so sometime on his resume, he has elevator operator in Chicago. And so this must have been sometime in the 70s or 80s. He was kind of a youthful person, left college, got a job as an elevator operator. I don't know if there are such people anymore. There might be in certain types of situations, but this is kind of an example where as the elevator became automated and we have that technology, it also had some impact on how the world operated. And so we should take technology as, I think in some ways, be aware of it, be curious about it, but also not glorify it or sort of mystify it in some way. It's always here. That's kind of the nature of our existence in some way. And so one good article that we found over the summer that's worth mentioning, and I think I recommend it to you for those who are interested in thinking about how this move towards artificial intelligence, robotics, automation is affecting the economy, is this article by Agarwal et al. Agarwal et al. Work in the University of Toronto at the center there. And this is an article that came out earlier this year, Artificial Intelligence, the Ambiguous Labor Market Impact of Automatic Prediction. And they basically look at the question, we talk about robots taking away jobs, what does that mean in practice? They find that the main area in which we have AI developing, just as a technology now, is this whole idea of prediction and data analytics. And so its impact, the impact of this technological change, they say, we predict would be in areas where there's a lot of human decision-making, a lot of question of risk analysis, a lot of questions about making prediction, and therefore then they'd look at labor market data to see where those types of jobs would be. And so jobs which are heavily involving this type of decision-making, we might think about how the technology of AI, robotics, automation would either serve to be a substitute or enhancement for existing work. And so they look at four main, there are a couple of others they look at. They look in the area of surgery. There's some very interesting work about Dr. Robot, the use of robotics in surgery and how that's actually improved some of the delivery of services in some regions. A very nice article recently in the New Yorker that I would recommend about the robots by D.T. Max, who writes about science and technology for that magazine. Drug discovery, so a lot of pharmaceutical companies are using this in terms of proteomics and looking at the ways in which we can think about better delivery of drugs, better design of drugs. And then now getting closer to our realm, people may be familiar, at least in the U.S., about the use of artificial intelligence by judges in terms of making bail decisions, which has raised some very interesting jurisprudential questions regarding due process, as well as questions about how to design the criminal justice system more broadly. And then they also look at the area of tax law as an area where these types of tools are used and will be used in the future. So it's a highly recommended article, and it's sort of the backbone for what we're thinking about in our own research when we're thinking about the impact on lawyers. And the big political aspect of this that you see in a lot of discussion about legal tech overlaps with legal tech startups, tech startups from a business perspective rather than a pure technology perspective. And the focus is on aspects of access to justice. And this comes up in lots of different ways. I know there was a 2012 JDV survey. 71% surveyed in the group were afraid of the costs of legal disputes, that the legal system was somehow, if not Kafkaesque, is obviously extreme, but more reality is expensive. Lawyers are hard to locate. It's not clear what the outcomes would be. If you look in the U.S., one of my favorite lines from the Institute for Advancement of American Legal System, which is a group in the University of Denver, in the U.S., it is expensive to operate in the gray. What does that mean? We talk about how a lot of the legal analyses, at least as works out in some classrooms, is very unpredictable. And the reality is it may not be clear what the answer to certain questions might be. You see this, for example, in U.S. discussions about copyright and fair use. You see this in questions about patentable subject matter when you look at intellectual property. But you also see it in more fundamental questions about constitutional law and rights. And that has a cost associated with it. And so this is where people think about how, at some level, maybe the legal profession, at least in the U.S., maybe has an investment in saying things are gray, that we're not sure what the law is, and so the only way to resolve this is to have two lawyers or more come and dispute and sort this out, and the gray will somehow maybe become less gray for a moment. But this really does raise questions about whether the legal system is imposing these costs by creating fundamental uncertainties. And perhaps tools like legal tech, for reasons that I'll talk about, can resolve it. And so this is also illustrated by another line that I enjoy from the ILES report, where they talk about thinking like a client. We're told in law schools, the stereotype, at least in the U.S., that you're being taught to think like a lawyer, and once you've managed that, then you've somehow mastered what you're supposed to do in law school, you can move on. But I think the approach that a lot of lawyers, people in the legal profession, are asking is, well, no, you should really learn to think like a client. In other words, what exactly is it that your client wants, whether it's a business client, whether it's a family law client, whether it's children that you're representing, whether it's animals that you're representing, right? You know, whoever your client might be, you need to think about what services you provide from that perspective. And so this is kind of an interesting mantra. It's an interesting way of thinking about this. And I think the value of legal tech is that it gets us to challenge a lot of the conventions and really address some of these questions about access to justice and what the legal system is doing, whether it upends it, whether the tech gets usurped by the legal system. It's kind of an open-ended question. I think that's something I'll make the case for when we get to legal reform about where this might end up. But I think it's useful for understanding legal tech as a way to really understand what is it that we do as attorneys and the broader role of lawyering and the legal profession. Right? So this is the perspective that I'm taking in terms of understanding the presentation of legal tech. And this is the background that we're seeing. It's sort of maybe a benchmark for where we think legal tech might be valuable at the end of the day. So what are some of the examples of legal tech? I can look at lots of different examples that arise. I'm going to largely speak about the first five. I'll talk about intellectual property as a special case, maybe briefly if I have some time, but I'll be glad to take questions about this. A lot of these may be familiar, but I wanted to kind of list these, and then we'll spend some time going into them in more detail. Data analytics, basically looking at the outcome of legal cases, basically looking at legal decisions. The word data we often think about as just purely quantitative data, and some of the data analytics might be quantitative, so it might be the number of convictions that occur out of a court, number of reversals. I mean, these are things that are numerical. But one of the things that's very interesting about modern developments in legal tech and tech more broadly is that the line between qualitative and quantitative becomes blurred. Because a lot of what the modern tech can do, as we'll see when we get to things like document creation and document review, is actually read. They actually can look at verbal data. So the words themselves become data. We might not think about that as data, but it is. For those who studied copyright, you're familiar of thinking about words and non-quantitative things, maybe qualitative things, as more data-like. And what that really means, has lots of different dimensions. Part of it is that everything can be reduced and digitized to 0 and 1. So there is you can think about that sort of a reductive approach, that everything can be reduced to numbers. But I think a more fruitful approach is to recognize that, we live in an empirical universe, and everything is data. Everything can be processed, everything can be accumulated in the mind. It's almost going back to sort of a Lockean view for those in the, looking at across the channel in terms of how we think about the world as a blank slate and then things getting imprinted. But it's also to do honors to the continent and not to privilege Locke, a Kantian view of how we take information and try to think about propositions that are either analytical and synthetic and so forth. So there's a very interesting theory of the mind that's behind what's going on with the data that I might touch upon. But do keep in mind that this notion of data is quite broad now. We're all data. I'm data. There might be some piece of software out there. It may be in that machine that's recording me that can take my face, and it now becomes a data point. And then it can take the face of everybody in the room. That's all data. The way I'm gesturing is data, right? The way I'm speaking, and that can be translated into something. Everything is data in this very broad sense, potentially. And that has some very interesting implications for legal tech. So we'll talk about that. Document review and e-discovery. Discovery, more of an American tradition in terms of the way litigation operates, but we'll see how the legal tech has affected there. But it has some implications even in systems where discovery is not as important in the process of trial and litigation. Document creation is one thing that I find particularly interesting because I view myself more in the transactional world of lawyering. So I'm interested in contracts and agreements and how parties want to sort of govern themselves, essentially, through agreements. And so I'm curious about document creation. And so we are seeing these legal tech capacities in the creation of documents as well as the review of documents. And then the way we think about a document is also very interesting now. We might think about a document as I remind my students, a contract does not have to be written to be a contract, but it helps. But of course, there are lots of things within the legal realm that are documents that have to be written down. So a judge has to write an opinion in the U.S. or has to give an order out. That serves as a document, right? That also becomes data. That has all sorts of dimensions in this particular universe. And so document creation, again, keep in mind the notion of document can be very broad. And I'll give examples of that. Next is rights enforcement. These are ones that are maybe familiar in the German context. People are familiar with flight right, with my right. In the French context, there are online dispute resolution systems that have come up that involve legal tech, and so forth. And so we think about these rights enforcement. I put that very broadly as a notion of how legal tech can allow people to either aggregate claims that they might have, and then to try to enforce them against whoever the party might be. And this is something that gets a lot of press in terms of looking at the cost of litigation and the access to justice issues that arise from that. And so we'll talk about that. And then finally, there's legal counsel. This is the Siri Esquire, to use that label. This is where you're using systems like Siri, systems like online communication to provide legal advice or help you sort of work through legal problems, right? And so we'll take a look at examples like that. The intellectual property of special cases is something we're still working on. I put it as a special case because of the special treatment of the intellectual property bar as it exists in various jurisdictions, especially when you look at the patent bar, trademark bars that might exist. So it's probably useful to think about these as separate in some way. In the U.S., we have a patent bar. We don't really have a trademark bar or a copyright bar. And there are special rules that arise in that context in which legal tech might have a different influence. This last case is especially important, especially when you get to legal reform. The United Kingdom, as people may know, have had some major changes in 2007, 12 years ago now, regarding the structure of law firms and who can practice, who can provide legal services. And one of the things under the UK legislation is to create an exception for members of the patent and the trademark law. So they still have this sort of realm where they can practice, and it's very hard for non-law firms, traditional law firms, to be providing patent law or trademark services. And so this raises some interesting questions from a legal reform perspective about how intellectual property attorneys should be treated. And intellectual property is a special case because on the one hand, there's a lot of interesting questions about how legal tech can be used to design patents, to draft patents, to design trademarks. We worked through one hypothetical we had over lunch a few weeks ago with a trademark attorney locally. There's tech that can help you assess whether a particular trademark can get registration. But you now think about the next level. What if the trademark assistant, if you will, the legal tech says, I'm sorry, your trademark is already registered, but you might want to try this. In other words, maybe if you use a different color, or if you use a different font, or might I suggest instead of using a funny little bear as your logo, maybe you can use a funny little, I don't know, substitute some other animal that you want. Funny little dolphin as your animal, right? So can the legal tech go to the level where it can actually design things like trademarks, or even design patents? So this is where there's kind of an interesting reflexivity to what's going on with legal tech potentially that might worth you thinking about it as a special case. And I'll maybe touch upon it a little bit here, but maybe more in our joint paper. So let's look at data analytics. You've got the example of Lex Machina for those from California. You may be already familiar with Lex Machina. If you're not, it's a very good tool developed at Stanford, by Mark Lemley and colleagues at Stanford, and now it's part of a separate company. And basically it collects information about patent records, very good source for analytics about if you want to trace the status of a particular piece of patent level litigation, or if you want to follow the history of a patent. Very useful, probably one of the forerunners in this particular area. You have Docket Alarm, also a startup in the U.S., that looks at full court records, not just simply for the IP area, but also outside the intellectual property area. We know Professor Dan Katz, who's also been has affiliation with Bucerius. Wisdom of crowds, accurately predicting Supreme Court decisions. So the development of analytical tools that draw on things like machine learning, draw on these analytics to basically predict, or at least to, I use the phrase retrodict, that might be a little bit misleading in some ways, but at least it's able to show or predict the outcome of various Supreme Court cases in some ways more effectively than human arbiters. And so some interesting data there, work as indication there about how might that arise. I mean, it'll be interesting to see how these data analytics work in the future, right? So obviously it's a very useful tool for academics. For people who want to study these cases, it's very helpful to have this information. For the practitioner, it's also very useful to give you a sense of where the law is going, and to give you a sense based upon the data, looking at the properties of big data, where a particular doctrine, a particular area of the law might be headed, or even to help you predict your individual case, the likelihood of success of that particular case. There, again, you need to be very cautious about, of course, extrapolating from the general to the particular, and then also from the particular to the general. And I'll talk a little bit about this when we get into machine learning in a few slides. But nonetheless, that's fairly possible, which raises some very interesting situations, at least when you're thinking about two sides to a dispute negotiating. What if one side says, I've run my data analytics, and I predict that I'm going to win with 100% certainty, or let's be a little bit more realistic, 80% certainty. And the other side says, no, I've done my data analytics, and the prediction is we're going to win with 83% certainty. And so now what's become maybe a battle between two lawyers has now become a battle between two pieces of legal tech. And then how do you think about introducing legal tech into an actual courtroom? Would that be possible? Would it matter in some sense if you're trying to make some determination, not necessarily about a particular case, but maybe about a particular piece of evidence, or making some sort of prediction about the validity of a patent based upon the data analytics, or the validity of a trademark based upon data analytics. And so we've looked at the factors for the validity of a patent, but if you actually look at the data involving patents that are very similar to this technology, they have been found and validated 83% of the time. I'll use that number again. What weight, if any, should that be given in some sort of proceeding? Right? So this is very interesting in terms of both thinking about an individual case and then thinking about how two attorneys might argue a particular case, and then finally, what relevance might it have in a courtroom in terms of how that case might be determined or adjudicated. And it's a very interesting question that are worth thinking about because somebody is going to raise it. It may not go anywhere. It may be the case that a court finds that these data analytic tools are just not relevant as an evidentiary matter, to use the language of evidence, or it might be the case that these legal analytical tools will be used like like an expert witness. Like we use sort of an expert party to adjudicate a particular issue or help with a particular factual matter. We use the legal tech as our own expert. Right? And so how then should the court system deal with that? So it's kind of an interesting point to think about with data analytics. As I said, document review and document creation is one of my favorite. I separate a little bit from document creation. The basic idea is you have some sort of a software tool that can look at some sort of medium. Here I have a server, or it could just simply be a hard drive, and then it can search the hard drive to identify all sorts of documents, right? And so this comes up, we think about it as a tool in discovery. Discovery in the U.S. system, as people know, is the process of fact-finding or initial fact-finding before the case goes to trial. And so one of the issues that comes up in discovery is identifying documents that are relevant. And often, if you're looking at a lawsuit that might get headline treatment in the newspaper, often these documents might be the explosive email, right? So the explosive email document that basically says, why don't you help me with this? I won't give you the obvious example. But okay, the email that might say, we're going to kill our competitors. We don't really care about customers. All we're going to do is kill our competitors. Right? So the explosive email, for example, in a competition lawsuit that gets abused to show the intent of the party. Well, this document review can search that with the software to find all sorts of these types of documents, even things that have been deleted, even things that have been theoretically expunged. So the document review has that capability, and obviously can do it a lot more efficiently than individual humans can do. Let me move on to talk about document creation. Lots of very interesting examples of document creation. And here we're talking about the legal tech, the use of legal tech to actually formulate a contract, to read a contract, to identify errors in the contract. And then we think about probably the next generation, and even though coming up now, where parties want a contract to say X, Y, and Z, and then the other party wants maybe terms A, B, and C. How do you meld those terms into a contract that might be, if you use the term bulletproof, that would be enforceable by the courts without any kind of overturning? So the Law Geeks, which is an Israeli startup that I think got some press that people may be familiar with, last year had a competition where it tested its AI against, I think it was about 20 attorneys, seasoned attorneys in the area of contract law. And the contest was to review several non-disclosure agreements. And I think altogether in this context, there are about, let's see the numbers, about 5 NDAs, 5 non-disclosure agreements, each with about 30 legal issues that were embedded in the document. So things like duration or terms that might have been left out, things that may not have been specified accurately. So there were deliberate errors in these documents. Altogether, each document was about 11 pages. We're thinking about 152 paragraphs, just quoting the numbers that had to be reviewed, with 3,000 clauses. So these are substantive documents that we're asking the attorneys, 20 attorneys, to review and to compete with the Law Geeks AI. And the Law Geeks AI, had accuracy about 94%, much better than the lowest performing lawyer. The highest performing lawyer was constabled for 94%, and that's all well and good. But then you look at the time it took to do this. So maybe at best you can get comparable performance, but I think what LawGeeks is suggesting is that the AI kind of outperforms at least this group of 20 attorneys. Maybe it performs as well as the best of the 20, but on average it did better than the 20 as a whole, and it did it in 26 seconds, right? As opposed to the 92 minutes on average that we saw for the average with the attorneys. So you have other software like this, like Seal, a lot of other legal tech. Seal software, again, does document review, due diligence. A lot of these technologies are being developed by startups, but a lot of them also are being developed in-house within some law firms. Right? So Littler Mendelsohn, a big employment law firm in the Bay Area, has developed software to deal with human resources compliance. And so a lot of this comes up within law firms as well as external to law firms, and we see the document creation. it's worth spending some time, because I find this fascinating. My training is my graduate training outside of law is in economics, but I find the machine learning very interesting because there's a long history in economics about cybernomics, game theory, von Neumann. So it's interesting to go back to this, and I find thinking about machine learning as very important. So I'll give a very brief introduction to machine learning because it's relevant for thinking about how a legal tech and what lawyers do work together. And so we think about artificial intelligence very broadly. A subset of artificial intelligence is this thing called machine learning, and the machine learning that involves something called deep learning as a subset of that. And deep learning then, we could have broken this down a little bit further, goes back to the basic stratum, which is something called a neural network, which is basically a way of modeling through a combination of software and hardware the human brain, right? The kind of connections between neurons and the synapses that occur in the human brain. And so if you think about the standard computer, I guess if you've done any programming, the standard computer is sort of an if-then instructions, right? So, if this is bigger than that, then you do this. Or if you think about a chess game, so, if a pawn, let's say, is within this ambit of your knight, right? So you think about the ways in which a knight can move, then capture the pawn. So if then. But the idea behind machine learning is to actually give the computer, give whatever the software system is, some data. And we'll talk about the different ways in which the data can be organized. And then it can analyze the data using and developing its own model of how that data should be optimized or should be analyzed to get a particular output. And so this is what's different from the machine learning versus the other types of computer programming that you might be familiar with. So you might have seen this, some headlines a couple of years ago about AlphaZero, which was, I think, Google's machine learning chess-based program beating another computer chess-based program. And so the difference there is that Stockfish had a set of strategies that were built into it so that it knew, it's a very complicated program as you imagine, but it's basically telling somebody, okay, these are the situations you have for chess, this is what you should do in those situations. Okay? So you have see this, do that, right? Those types of instructions. But for something like AlphaZero that uses machine learning, what you do is give it various patterns, ways in which games are played, and from there it figures out some sort of model for how you should think about playing games of chess, and then it applies that to a different model. So it is, as the name suggests, a form of learning. If you think about it in terms of pedagogy for law, it's like you tell a bunch of students, here are a bunch of contract cases, and this is how they came out, and we can look at the contract cases, and then we can figure out, okay, what the court does is look to see whether there's something called an offer, and then it looks to see whether there's consideration, and then it looks to see whether there's been some sort of breach, and that becomes our model of contract. And now, here are 500 other contract cases. We're not going to give you 500 other. I'm not that mean a professor. Here are 3 other contract cases, and now read those and see how those cases come out. And there's a very interesting connection, I think, analog, at least between what we think about machine learning and common law approaches to the law. There might be also analogs to civil law approaches that we can explore, but being trained as a common law attorney, it's very much like what you think about with the common law approach of analogical reasoning. Right? So you see some cases come out a particular way, you generalize, and then you look at some other data and see how it comes up. But there are some catches that I'll talk about in a minute where that connection is not completely accurate. So the other one that comes up with machine learning is you see these in some Google applications where they can predict the word and complete sentences. So they actually can write something for you, right? Theoretically, they could write they could write a paper, right? If you could program it right. And so again, it uses some machine learning. It looks to see patterns of how people have written emails or letters in the past. And then from that that information, it kind of generates some prediction about what that word would be, and somebody can take that word or not. So there's one example that I found really interesting, again, in a recent article about these types of technologies about writing, where the author of the article was writing an email to his son, and he was going to write the sentence, I am pleased, and he had written IMP, the first letter of the word pleased, And then the AI system came back to him and said, proud. And, this is kind of a sad state maybe that he had never thought about being proud of his son until the computer had told him this, or at least at that moment he wasn't feeling particularly proud of his son. But he was pleased, so that's good, right? It could have been something else. I'm problematic, or problematized, or whatever. He wasn't saying anything like that. But so he ended up saying proud. But the point of this is the system could recognize he's writing to his son, so maybe he wanted to say something positive. Maybe he could say the general tone. Maybe, I don't know how far these AI systems can go to gauge the relationship between father and son. Maybe there was some sort of nudge there to say, hey, come on, isn't it about time you said you were proud of your son? I don't know if it went that far. But nonetheless, it worked out that way in terms of the completion. So there's this machine learning. And here's where it gets really interesting in terms of the ways in which we think about these working and the role of the lawyer. So this has come up in some writings about machine learning. And there's two types of machine learning. One is called structured machine learning, and the other is called unstructured machine learning. I'll just talk about each in a minute. When we look at structured machine learning, what the system has as its input is the data organized in a particular way. So the example that one data scientist has given is, supposing the output that you're seeking is something like a credit score. Is this person creditworthy or not? And so you can have the organized data that's organized among things like income, past defaults on the loan, how much of indebtedness. So the data is organized in a particular way according to these particular labels. And then what the machine learning program does, or the algorithm does, is fit the best model to that organized data. So those who might have some background in statistics, maybe this would be familiar. You often, one of the jokes about economics is we can take any set of data out there and fit a perfect line through it, or not a perfect line. So even whether it's linear or not, we're going to. But now the idea is that the model can be any form, right? Whatever the form might be, that would best fit this particular data that you have. And then from that data, you could get some sort of output. And so then the organized data, for example, might put certain weights on income. It might put certain weights on past indebtedness. The obvious danger issue that people have pondered, what if you start putting input about gender or race or religion or any other types of maybe suspect classification that could be used for discriminatory purposes, which again shows you some of the problems with these systems. But nonetheless, the idea is organized, the data is organized in some way. The model then is created, there's output, and the key to the machine learning then is you then feed it new data, and then it can update the model. That's where the learning can come in, and then it can go to what the output would be. And so the difference between this and unstructured machine learning is, for the unstructured machine learning, the data is not necessarily organized by any type of category. It may just simply be given sort of as raw data, if you will, that is done through sort of clusters of things. And then when the clusters are looked at, what the machine is really trying to do is come up with a model by identifying patterns within the cluster of data. So however the data is clustered, whatever the information might be, the machine looks at that and then comes up with the output. Now, I can go into this in a little bit more detail, but I think it's important to see the difference between where there is some sort of organized data, which is a lot of where the structured machine operates now, a lot of machine learning operates, and the unstructured. Because one of the big differences, of course, is who organizes the data for the machine. The unstructured model is sort of saying you feed the data to the machine, and then the machine then maybe does its own organization, or it does whatever it does to the data to come up with whatever the patterns would be. But who then does this organization? And so one argument that you see, and I'll be glad to expand on it, is the way in which these systems would work is that you still need that basic organization of the data. Somebody has to tell the machine. And this might be, at the minimum, I think at the minimum, what the attorney might be doing when they're trying to use these machine learning systems. So if you think about using machine learning for drafting a contract, for example, the unstructured approach would simply say, here are all these contracts that are out there that we put in some sort of data form that the machine can analyze. And then the machine then looks at these and sort of comes up with its own sort of pattern of what a good contract would look like. And in practice, it might be situations where it does come up with the equivalent of I am proud, or it might be coming up with the equivalent of I am, well, think of another word that begins with P, that's not as tasteful that the machine might come up with. Or it might come up with something like I am blah, 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 blah. Okay, I can reject that, but it just hasn't learned at this particular point, right? And so I guess I am perplexed would be another kind of example. Well, with the organized data, the data is sort of structured in a particular way, and then it goes through the model to get a particular output. And so this is kind of important as far as how this organization comes in terms of what the lawyer's role might be in this use of machine learning, for example, for contracts. Okay, so that's kind of a point I just wanted to emphasize. The unstructured machine learning still has a ways to go, but even with the structured approach, you see the role for it. So what are some of the legal applications that arise? I mentioned contract drafting. Could it come up with opinion writing? If you think about judges writing an opinion, this is kind of very interesting, especially when you look at many of the Supreme Court opinions that come from the U.S. where you don't get one opinion. Sometimes you get several opinions, and it's very hard to square them. And so could the justices use this technique to come up with an opinion that would be more, at least understandable as to what it says? But, we think about this as contract, we think about this as writing, but maybe it would also have applications for reading, right? So in other words, you have the various opinions from a court. Could the system then learn to figure out, well, what exactly is the court saying, right? In other words, if you're thinking about what the court said in this scenario, how would it then apply it to another scenario, right? So it's kind of interesting to see those applications that arise. Okay, so there's also the possibility of assessing contract terms. So let me move on a little bit. I won't talk too much about rights enforcement. People may be familiar with flight right and my right, and I mentioned e-just as the French system. People are already familiar with this. And this is the legal Siri. That you're seeing some applications where you can pose questions like you do to Siri on your iPhone or Alexa, whatever the program might be. What is Alexa called in German, actually? What is it called? Is there a different name? Alexa. Is it just called Alexa? Let's keep it simple. Doesn't try to be culturally appropriate or culturally localized. All right. Okay. So that's legal counsel. Let me just finish up then by getting into the gaps filled by legal tech. Sort of give you where the legal tech is, what are some of the gaps. So this is where we think about the cognitive psychology of lawyering. And there is a lot of literature about how, when you think about the practice of lawyering, lawyers are subject to the same kind of cognitive biases, if you will, or cognitive gaps that were identified by Daniel Kahneman on the left here and Amos Tversky, his colleague, and now are sort of articulated in a book called Thinking Fast and Slow. And very complicated, very rich literature here that I'm not going to do justice to. But if you think about the way in which, what Kahneman and Tversky identified is, if you think about at least one view of lawyering that sometimes may be associated with the law and economics approach to lawyering is one of, rationality. They can assess the benefits and the costs, the potential risks, and then, find a solution that maximizes the client's, if you will, expected value or expected utility from some sort of legal strategy. And so this is, where this kind of economic analysis, either in a very strict form or even in a very loose form, comes into play, right? It doesn't have to be a very strict model that, we can sort of say we've got to act in a rational way with our clients and try to get the best outcome. Even that language has lots of different valences, but also has a sort of a subtext of sort of economic rationalist thinking. What Kahneman and Tversky has pointed out is that when you look at people in practice, people actually don't do this kind of complicated calculations of what would be the best outcome. They often rely upon heuristics. They often rely upon simple rules that are sort of developed wherever it might be psychologically. So they point out that some of these rules can actually lead to misleading results or confusing results or unpredictable results. Okay, so I'll leave it there. One aspect of this that they talk about is in the area of how lawyers deal with risk. or people think about risk more broadly. I should point out that even though Kahneman and Tversky, they do have, at least especially Daniel Kahneman, does have some applications to legal context, they were talking about psychology more broadly. Right? And so my point here is that these broader issues of psychology also have some implications for how lawyers behave. And so one example of that is in the area of risk. There's a 2012 report from KPMG that looked at in-house counsel and some of the criticisms of corporate clients of their in-house counsel. And one consistent theme was that lawyers are not very good at assessing risk. They're not very good at assessing technologies and whether we should adopt them or not. And that's something that lawyers need to be better trained at. And so we can think about this, or in terms of what exactly are the lawyers' attitudes towards risk. Do they tend to be more conservative? Do they not really understand risk all that well? Do they tend to maybe fall back on certain Kahneman, Tversky-like heuristics rather than actually assess this? One way I like to think about this is to use Google as an example, where there is sort of an interesting tension or interplay between engineers and lawyers within Google. And so we talk about thinking like a lawyer, but there's also talking about thinking like an engineer. And so, one example of that from practice for people who are familiar with the U.S. copyright system, maybe with the Google Book Project. You remember about a decade ago, Google undertook this amazing project where their basic idea was to digitize all the books in the library. Some of them were in the public domain, others were not in the public domain. The ones in the public domain, of course, raises questions of copyright. Now, I guess a rational lawyer of some sort, or any lawyer, might have looked at that decision and say, well, there are 1 billion copyrighted books that Google wants to copy. The chance that these will result in a successful lawsuit in copyright is probably pretty high. I don't know what it would be, but if, billion, even if it's not 1 billion, even if it's like 10 million copyrighted books, one of them probably is going to lead to a successful copyright judgment against Google. Google did it anyway, right? In other words, they took the risk, and they obviously did it, and lo and behold, I think they got a victory, right, with the judgment in the Second Circuit that this type of digital copying for search that they were doing was fair use. And so here we think about this tension between thinking like an engineer, which is sort of do it, and then ask for forgiveness later, if you will, versus thinking like a lawyer, is kind of representing this different attitude towards risk. And looking at it a little bit further, Kahneman and Tversky talk about something called loss aversion. And this is something that they find is a psychological bias that it can be manifested in many ways. So one way is if I give you an option, but I present it as a game, right? So that if you do something like this, 20% of the people will survive. You'll treat that very differently than if I phrase it as, if you do this, 80% of the people will die. Those should be exactly the same, and you should treat those the same, because depending upon whether you want to take the risk of people dying or people being saved, it's the same outcome, right? But they find that when it's phrased in terms of a loss, people are less willing to do that. But they do treat those two outcomes very differently. And there's a very interesting literature about how this affects things like settlement and litigation and so forth. And that's kind of something we talk about in the paper. But it's also what I call it in the paper, as I said earlier, lawyer fail. That's harsh. Let's call it as a lawyer gap, right? That maybe this loss aversion affects those types of behaviors and might come up in lots of other areas as well. So here the loss aversion literature on lawyering both talks about attitudes of clients. Sometimes lawyers exhibit loss aversion because maybe their clients are loss averse, and the lawyers are simply representing the interests of the client. But there are other situations where the literature finds that the client maybe is deferring to the lawyer, and the lawyer is in fact loss averse, and therefore is acting in this way. Okay, so where exactly does this come into play with the Kahneman and Tversky point? So the Kahneman and Tversky point then, with thinking fast, thinking slow, now tied into the title of the paper, is that, okay, there are these heuristics, and now there is sort of a question about how should we deal with these heuristics? Should we somehow try to cure them? Should we somehow try to deal with them and just sort of accept them as they are? And so in the Kahneman book, what the author does is say, okay, there are situations where people think fast. We need to identify those situations. So that means thinking fast means they are looking at these heuristics and shortcuts and making their decisions. And thinking slow is one where the parties are deliberating. They're doing maybe not exactly what a rational economic thinker would do, but they are thinking more. They're sort of recognizing, wait a minute, 80% dying and 20% surviving, that's the same thing. I should treat those exactly the same way, right? So that's the thinking slow aspect of this, however that occurs. So in the paper, I talk about how this also corresponds to lawyering fast and lawyering slow. And so the lawyering fast notion is that in the practice of law, there are things where people rely upon instinct or hunch. Some of the literature on the psychology and lawyering talks, for example, about how judges, if you talk about judges, they sometimes say, I just decide things. The classic phrase from the United States about pornography, right? What is pornography? Or actually, what is obscenity? I know it when I see it, right? It's just, presumably some judges have seen more than others, and then they have sort of a hunch about what it might be, right? But that's the idea about instinct or hunch. And the idea then about legal tech is, to the extent that we are skeptical about the legal hunch or the legal instinct, that legal tech can provide ways that can at least move towards thinking slow or lawyering slow where it's appropriate to do so, right? And so we look at this, for example, in the context of data analytics. We also think about this in terms of assessing contract terms, as well as looking at document review, that it kind of replaces this maybe over-reliance upon lawyerly instinct, lawyering fast, but maybe lawyering slow might be more appropriate. And there are lots of other dimensions of that, which I'll be glad to talk about in questions. It's important then to also talk about some of the limits of legal tech for curing cognitive bias. I just want to raise these. Could there be abuse of data analytics? I mentioned the example of somebody one lawyer using data analytics to say, well, my algorithm says there's 80% probability of success here, therefore I wisely recommend that you settle. Or could this information be used as evidence in a trial to say, well, if you look at information about other patents that are similar to this, 89% of those were found invalid. So there's that question about abuse of data analytics that people have talked about largely in the area of racial bias or gender bias in the use of these techniques, especially in the bail context. Sometimes we think about this as a cure. I presented this as a cure to lawyering fast. But, could we just be mechanizing these cognitive failures? It all depends upon how it's implemented and who's doing it. And that's kind of important to understand. The last point I want to leave you with, or to raise here about, before I get to the legal reform, and I'll end the talk there, is machine learning. And I mentioned this in terms of the structured and unstructured approaches. And one way to think about the structured approach is that it kind of relies heavily on deductive reasoning. And so it kind of goes from sort of the general to the specific. It generates the general and then goes back to the specific. And then unstructured machine learning is sort of working more with an inductive approach. And so one of the criticisms of machine learning that I think is worth mentioning here is that what we do as lawyers is something called abductive. I mean, we sort of kind of start wherever we need to start for a particular problem. So we might see a case that fits into a general category, and then we work from that general category to how this case might work out, and then sometimes we may go back to then to think how about that specific case might fit a general category. It's not clear that machine learning can go as smoothly, assuming lawyers do that smoothly, from the deductive to the inductive, right? And so that's actually kind of important. Certainly we think about in a common law system, abductive reasoning is important, but certainly in a civil law system, it's equally important, I think, not a bad characteristic of what goes on. One of the things I've learned since being here is I probably came in with I don't think I totally did, but with some very rigid stereotypes of what civilians do and what commoners, I mean common law people do. And, as I've sort of, looked at this more, not just simply with my time here, is that maybe there is a lot of overlap. It's just that it comes from lots of different perspectives. But it's important to keep this in mind when you look at machine learning. Okay. Our paper also looks at some organizational gaps, both inside the law firm, and so we talk about hierarchy in the law firm and how you might have a system where if you're thinking about lawyering fast and lawyering slow, the partners may be the ones relying on instinct, and then maybe the associates are the ones then who are given the task of thinking slow, of trying to figure out exactly the bases for the partner's instinct. These also affect incentives for lawyers. If you're thinking slow, you might like hourly billing, right? You might like different types of billing practices. It might affect career mobility. I'm simplifying quite a bit in the paper. Basically what we're doing here is talking about how these cognitive biases that we think occur with lawyering either get magnified by the organizational setting of the law firm or might even get moderated a little bit. But where legal tech comes into play is in challenging these different areas so that legal tech can level hierarchies in the firm. That can work in lots of different ways. A bad way, of course, is you level hierarchy by getting rid of the bottom. In some ways, that's a point of leveling. But we worry here about whether this legal tech might take away this associate position or associate track. It might have some effect. It's worth thinking about. But it also might open up the possibilities to have smaller law firms or competing law firms as alternatives to the big law firm. Right? So legal tech has several different directions it can go. It can also affect career mobility. I mean, the way we think about the structure of the legal profession is, we're obviously are serving our clients, but we're also thinking about moving in some path to whatever the ultimate goal might be in terms of the legal hierarchy. Legal tech might be changing that in some way. Okay, so one of the things also to think about is professional regulation. What do we mean by a legal service? And the notion of legal service has kind of two effects. One is on non-law firms in terms of what is unauthorized practice of law, but it also has an effect on law firms in terms of what the law firms can provide, right? And so what legal tech does is maybe challenge what is a legal service. And one of the ways it challenges what is a legal service is to recognize that part of what lawyers do has sort of a computational aspect to it. And so, I give the analogy to researching case law. So, for example, if I'm trying to identify a case, well, anybody can identify a case. Is that technically a legal service? If I know a little bit about how cases are decided, that is no longer a legal service at some point. And so things like librarianship and so forth becomes very separate from the service that the lawyer provides, which is reading the case, analyzing the case, making a decision based upon that case, and so forth. So we can think about legal tech doing the same thing, but in terms of thinking about the computational aspect of what lawyers do, right? Sort of identifying that a lot of the legal decision-making has this computational aspect. And we can think about the computation as not a legal service that would affect how non-law firms would operate. But we can also think about how the computation aspect enhances existing legal services, which then can also liberate law firms in terms of using the tech in their own practice. I'll talk about this in some more detail. I realize I'm going over, but fortunately towards the end on legal reform, which is probably a good place to end, and then we'll open up for questions. So three possibilities for legal reform: vertical integration, changes in the underlying rules for professional regulation, and then finally a change in the culture. And so when you think about vertical integration, this is sort of the model that we're seeing in the U.S. You have a lot of law firms that are basically becoming law tech companies in the sense that they're integrating the things that law tech companies do within law firms, and largely that has not created a problem under the professional rules. Right? In some ways, it's no different from a law firm having its own library. Most law firms have its own library. Is the library somehow not a legal service? No. It enhances the legal service, and therefore the law firm can have a library and provides that. Right? And that's sort of the model in the U.S. As I understand in Germany, this creates more problems in terms of this integration. That's something we're talking about. Another possibility is that you have law tech companies that integrate law firms, right? So the vertical integration goes the other way. This has posed a problem in the U.S. You look at some of the reforms in the state bar in California, in Utah, and in Arizona, they're largely trying to address problems like this. To what extent can non-law firms provide legal services? And that's kind of a very interesting development, which I think will go in maybe a predictable way. Finally, we can think about rethinking professional regulation, redefining the legal service. What do we mean by a legal service? And that is something that a lot of the, I mentioned ILES, the Institute and University of Denver, is often thinking about. Who can practice law? Why do you have to have a law degree to practice law? And there are many states who are saying, well, maybe you can get some other type of degree, which will then allow you to provide certain types of legal services. So in the UK, the often example that's given is of drafting wills. That does not have to be done by an attorney in the United Kingdom. And so that's an example where the notion of a legal service has excluded that. A professor at Stanford, Deborah Rohde, did a study several years ago about do-it-yourself divorces. So I think in California, you could just, at some point just get the forms and do it yourself divorce. Not a happy, well, maybe it's a happy thought. I'll leave that for you to decide personally. But you have the form. The point of her study is to compare do-it-yourself divorces with what divorce attorneys were doing. And I'll try to get a citation to her study, but she found, her finding was that divorce attorneys had a lot more mistakes than the DIY, the do-it-yourself practice of divorce lawyers. Maybe because the people who do it themselves had more at stake, so they wanted to make sure they got that divorce right. Or it might have something to do with the practice that made this. So we can think about legal tech maybe moving in that same direction, if it goes in that direction, which then affects what do we mean by a law firm. This is something, again, that's very important when you're thinking about legal service. One thing I do want to end with, which I think is very important to keep in mind as we try to understand legal tech, is we kind of have to think about the understanding of what it means to be a lawyer. I think there are sort of set notions which, tradition is a good thing, tradition is a bad thing, here as in everywhere. But we have to sort of think about the notion of lawyering. And I think at the heart of when we think about lawyering, there is this notion of legal complexity, right? And the way legal tech then is affecting the way we think about lawyering is also reflected in the way we think about the law. Do we need the law to be this complex? So when you think about the human expert, we think about specialization in the law that is sort of necessary because the law is so complex. And does it have to be complex in the same way that medicine has these specialists and so forth? We think about then of legal tech providing certain types of elegant machines that are made possible by certain types of technological capacity. But one of the things that I really find interesting about a lot of these legal tech, especially some of the data analytics, is that it does challenge legal complexity, right? So if you can have an algorithm that can do some prediction about what the Supreme Court is doing and how they're coming up with decisions, that really does something about the mysticism, the Delphic view of what the Supreme Court is, and that's got to be a good thing, I think, in the long run, or we can question, right? Because ultimately the good thing is going back to the point about access to justice. Obviously the law is about human needs, right? The reason we have a law is not for its own sake, but we have certain needs. I don't know if the needs necessarily require complexity. Do we want complexity for its own sake? And I think legal tech is sort of shaking this up in terms of how we think about the cultural understanding of lawyering, as well as think about the expertise of lawyering. And so I'll leave you with this final image about the future, that we have this melding of the legal mind with the tech mind, the legal mind with technology, which then raises the question about who is the expert in these situations. So thank you for your time. I'm sorry if I went on, but nobody stopped me, so I took the time. So thank you again.
Okay. Yes, please. Thank you so much, Professor Ghosh. Yes, okay. Thank you so much. This was fascinating. It was stimulating to listen to you. I would like to know now if we have any questions, or maybe we need to digest this very rich presentation a little bit longer. But any questions from the room right now? Let me then suggest something, because what we're talking about, and we had many discussions about this, so something that came to mind during your the discussion that the presentation you made now is that we're trying to bring technology closer to the law in order to support and assist the law. But I'm wondering if in the future this will not be a mutual rapprochement where also the practice of law comes closer to technology. And specifically, I'm talking, you mentioned the contract drafting. What if we came up with a standardized form of contract drafting that are more easily readable, or maybe opinion drafting, or in the extreme, possibly legislation drafting, so that technology would itself shape the law and the practice of law.
Can you hear me? It's on, right? Yeah. No, I think that's right. As I mentioned in the second slide, I think it is, it's a symbiotic relationship. It goes back and forth. It then becomes hard to predict. I don't know if any, my internal machine learning may not be capable of sorting all this information out. I don't know if any actual machine learning could do that. But I think this goes back to the last point about what we think about the culture of lawyering, right? I think, a lot of the legal tech boom came because of changes in technology, but also because, at least in the U.S. and I think in other jurisdictions, you had the downturn in 2008, and in some ways the legal market still hasn't fully recovered, or at least it certainly was never the way it was in the 2000s and even before. And so people really had to rethink what lawyering is. We've had to do that in law schools, as you see both here in Bucerius and in U.S. law schools, in terms of the set of skills that law students need to develop and what their understanding has to be. I guess, so at that level, we think about then the lawyer, the newly emerging, newly minted lawyer as sort of a pioneer that maybe comes up with uses of this type of technology, much like we think about, the large corporate law firms in the 80s coming up with different types of contracts, largely without tech, or at least the modern sorts of tech that we're talking about. And so that might be happening more in a decentralized sort of way. I mean, I think there, Gillian Hatfield, Professor Gillian Hatfield at Toronto, has talked about garage lawyering. I don't know if that makes much sense in the U.S. So, but the idea is that you have a garage in your house to keep your car and to keep all your things, but the garage is often also is a symbol of a laboratory. So, for example, Hewlett-Packard, they had their first laboratory was in their garage in Palo Alto. And also when you think about music, we talk about the garage band. So people, usually young men, I guess, it could be anybody, go into their garage and they, set up and they develop their own music. And there are certain types of, successful bands that started out with in the garage setting. So what Professor Hatfield is talking about is maybe there is going to be something like garage lawyering, whatever that might be. It might not be in an actual garage. I think maybe clients would be very hesitant to visit somebody in a garage, but it might be within like the warehouse district. You have these types of large spaces that are open where, new lawyers can have startup law firms, right? And so that might be possible. You sort of see that a little bit in the Bay Area.
Yeah, co-working spaces.
Yeah, you're right, those types of things. Lots of ways to look at that. I mean, is that a sign of the future? Is that the sign of how bad things are now? I mean, there are a lot of people in that setting who say, well, I want a big law firm shop, right, because I can get health care, or I can get this and that, right, these types of benefits. But at the same time, I mean, the glass half full this is kind of where the entrepreneurial future might be. And so we see that coming up in obviously the Bay Area, lots of things are happening, but you see this even in certain parts of the Midwest, like Cleveland. They talk about graduates starting their own law firm. There's talk about using this type of space in other areas within the U.S., which I could get into. And so, maybe that's going to happen. I'm rambling a little bit because I'm talking about the future, and as I ramble more, we move further into the future. But I'm trying to give you a sense of where this, the positive side of this is. The negative side is, you talk about the practice of law, there are clearly institutions in the law that are entrenched. Courts. Are courts going to be amenable to technology? To a certain extent, they will be. But if you're representing a client and you're doing it in the context of litigation, you still have to use the court system in some situations. So then we think about maybe legal tech providing alternatives to that. Maybe some of the online dispute resolution would be a way that happens. I remember I went to law school in the early 90s, and ADR was the big thing. I remember interviewing for a law firm in the Bay Area, and I was working with a professor who was doing work in ADR, and I was telling him, happily naive law student, oh, I'm doing this, I really find ADR interesting. And this attorney was sort of this, maybe he was in his 50s or maybe 40s or 50s at the time, looked at me and said, that's a bunch of crap. So that interview didn't go all that well. But even ADR, which I think is something we take for granted now in some ways, had a lot of resistance. But that's sort of the point behind the story, is that you do have these entrenched things that might be resistant to change, and then, obviously things change around them, right? So I think only the imagination is probably the limit here, and so fora like this is kind of helpful to think about that.
I think so, because we're talking about the future, so
yeah.
A lot of imagination is required. Any questions, please?
I guess kind of on that subject, I always like to ask this question when I've gone to talks about legal tech, because as future lawyers, at least some of us in here, we want to think about how we can be valuable, and that can be difficult to do when you just graduated, you don't have any experience. But a lot of the things that maybe young associates used to do, like document review, for better or for worse, aren't really going to be left in our hands to the same extent, at least. So I just wanted to know, especially as an academic in the U.S., I'm from Michigan, which I didn't realize you went there for undergrad, also go blue. But if you guys are seeing any changes in how schools are trying to incorporate this, because at least Michigan has talks like this, or they have classes you can take, but
yeah.
And I know, but it just feels like technology changes so quickly.
Yeah.
People thinking of finding ways to help students learn how to use the technology. It might not be quite there yet, but that feels like a way we could be useful as the younger generation coming in.
Yeah, no, I think you need to learn more in law school than just the doctrinal things, or even if you learn the doctrinal, how it's used. So what law schools are doing, I know at Syracuse, the New York State Bar, they're not doing it just at Syracuse, but is really offering courses on technology and law. I don't know what the idea is sort of to educate how these technological tools are being used, and what the future might be. And so these are not just simply doctrinal courses; they're kind of like legal practice courses. So I think a lot of law schools at all levels, we're teaching things about how law firm practice would look like, how to set up a law firm, and I think tech has to be part of that education. I think a lot of it depends upon, again, what the course is trying to teach, what the professor is trying to teach, and why. I know Georgetown has a course on legal tech, and they're trying to incorporate teaching students programming. And that's probably useful. That's a good skill to have. And it all depends upon how it's implemented and what it's used for. But I think that's kind of the kind of skill set that a law student should think about developing. We had one student, she did a JD at Syracuse and worked in the tech transfer clinic that we have, and then she did her master's in computer science. I think she graduated from law school. She had an offer from one of the firms in the Bay Area, but then she decided to stay 1 more year and do a master's. Able to have the resources, we were able to help her through the clinic to give her the resources to get a master's in computer science from Syracuse. And so there are students who are trying to do that in terms of thinking about interdisciplinary approaches. So it's a little bit like, to me, from my perspective, and doing my graduate work at Michigan in economics, a lot of this is sort of deja vu, because at least in the 80s and 90s, everybody was trying to, you had to learn economics, or you had to learn, statistics or spreadsheets, and that was helpful if you're doing antitrust work, and even some obviously basic damages type work litigation. You need to know economics and how to do a spreadsheet, and so that was probably wise words overall, I think, and I think it's infiltrated the culture. And so when I hear a lot of legal tech debates, I just see the same thing but with another set of issues. The question is, personally, I'm a little bit less familiar, obviously, with computer programming than with economics. There's a lot of, as I mentioned, a lot of these issues about machine learning sort of can be traced to debates in economics in the 40s and 50s. But nonetheless, I think about what the skill set would be, and I think learning a computer language is probably not a bad idea, or at least being conversant in it would be something that's worth developing. I think some law schools are doing that.
Let me also just add something to your question. So in the law firms at some point, and that this relates to how technology penetrated and sort of replaced people in law firms. At some point in the law firms, they took away the typewriters and they gave all attorneys computers. And so then there was the great concern, what happens to all the secretaries or legal assistants? They're redundant, they're no longer necessary. Well, what happens in most places was that these legal secretaries took a course or two in IT and all moved to the IT department. So that's more or less what happens, and I anticipate that that's similar.
Yeah, and maybe somebody has studied this. I mean, just to look at the and for example, with the introduction of computers in the workplace, there was some talk about having a paperless workplace. So that was one big prediction. Any workplace I go to is just filled with paper. This is very simple economics, and I apologize to Bern for the simplicity of this, but with computer technology and printers, it's very easy to produce paper. So when the cost of producing something goes down, you're going to produce more of this. That's why every office is just filled with more paper, not less. I mean, there are obviously digital forms of that, but you also see still more papers. How this relates to your point is that with the development of the computer technology, I wonder how much more document creation goes on. Certainly it becomes easier to do that. It now becomes cheaper to file a complaint because you don't have to type it up. You have a standard form that you can then just kind of cut and paste, and obviously the legal secretary becomes the legal system.
So we have a question.
What would you say with regard to the openness of lawyers, for example, in Germany or in the U.S., especially as you do have the direct comparison or with regard to other European countries or other countries, to legal tech itself?
Yeah.
Is there a big gap, speaking about gaps?
Are you talking about the gap across countries?
Yeah.
Yeah, this is something, I'm still sort of grappling with. Other people may be better at looking at what the metrics might say. That's something I need to look at for this project in terms of looking at the technology diffusion. Certainly, I think both countries are talking about this issue. And obviously, I'm biased when I say that because I'm only talking with people who are talking about this issue. So I assume it's fairly salient in Germany, but obviously maybe that's just reflecting what I've been doing research on here. Certainly the U.S., you think about the major, all law schools are talking about legal tech in various ways. The American Association of Law School always has some sessions on legal tech. They had a very nice set of workshops over the summer that I was able to attend remotely on legal tech, and that's been very helpful both in writing this paper and also in terms of my teaching. So I think it's something that is talked about. I think the question is how it's talked about. And this kind of goes back maybe crudely to that picture I had about vertical integration. I think, I think in the U.S. it's viewed as an opportunity. There are obviously issues that arise with that opportunity, but I think it is viewed as an opportunity. I get a sense in Germany, I don't want to simplify things at all, that's viewed more as a challenge. I mean, you have this, you've got this, this is the stereotype about the U.S. being wild and open and, Wild West, I mentioned the 3 states that have been the most movement on legal reform, California, Utah, and Arizona. They're all west of the Rocky Mountains. So they're all, they're the Bavaria of the U.S. Sorry for that stereotype. That might be not a completely accurate stereotype, but in any case, even as a stereotype, But I get a sense in Germany that there's a lot more tradition. Maybe this is completely wrong how that's characterized, and for whatever reason, right? And I don't know whether this is civil law versus common law. I've thought about that. But maybe just the nature of the profession, the nature of training. I mean, obviously, Bucerius, I think about Bucerius Law School, it's not like any other law school, right? And I have had some experience with other German law schools, and they're all wonderful. They all have something to offer, but there is sort of more of a homogeneity in legal education that I see, except for outliers like Bucerius, than you'll see in the U.S. So that might also affect some of the differences.
Any other questions? Yes, please.
According to what I heard, automatic prediction of the outcome of cases has been forbidden in France this year.
Right.
Do you know some details, and are there some similar concerns, moral concerns in the U.S.?
Yeah, I'm still trying to grapple. I know a little bit about that French legislation. It's about using the legal tech to predict the outcomes of cases, but it's a little bit more complicated than that, right? Because it also has to do with identifying judges and the publicity surrounding it. So I assume I can do it in my own home without a problem. I can do it in the comfort of my own office as long as we don't publicize it. And so I'm still not sure completely about the contours of the law. I don't think they have any prosecution.
Does it deal with criminal cases?
I don't know if it's limited. Is it limited to criminal cases? It might be limited to Turkey, probably.
So I think what it says is that you're not allowed to use personally identifiable information of judges or any kind of predictive or statistical processing of case files. So you're actually wrong. You're in jail right now because even in your own home, if you draw a table with 3 names and like 2 decisions each and try to figure out how many cases they have actually decided one way or the other, welcome to a French prison. Nobody has been prosecuted on it because we all know that it's obviously politically motivated. It happened after someone discovered how blatantly racist immigration things are handled. And so I don't think that we're going to see some real world application of that anytime soon.
Yeah, that's
but it's there.
Yeah, it's there. I mean, I think the general question is a lot of the success of some of this legal tech involves access to data. And there are some real questions about access to data. We'll talk more about the French. I don't want to get bogged down in the French. I thought there was some requirement of publication or whatnot. So if you do it in the privacy of your own home, I guess you're a criminal then. Even if you don't publicize it, with respect. But this access to data is a big issue. And I think that's very important. And I think that the heart of the French legislation, criminal legislation, not just sort of the prosecution, but what it says about how you can use data. It even goes beyond just simply access to the data. It also talks about processing the data. And so in the U.S., there's lots of questions about obviously federal government data. There's a Supreme Court case, the U.S. Supreme Court case this term. It's going to be argued on December 2nd. It's a very important case about copyright in state legislation. And so and that has implications for other types of state legal documents and state legal information and state legal records. So that's a very important case to watch, depending on what the court is doing, because that not only has implications for data analytics and legal tech, but it also has implications for just access to justice and just the questions that you see in the French legislation. So I think I get the impression that that access to data is obviously a bigger issue. GDRP, I should say it, I guess. Questions about how the GDRP might affect some of these data analytics, whether it by itself, independent about enhancements, if you will, like the French legislation, might have some negative impact about how you can access and aggregate this data. And so that's important. That's why I started my talk by talking about how broad data analytics is. Right? It's not just simply quantitative. In a legal context, it's qualitative data as well. And that's very important for some of this work that's going on.
Is there any further questions? All right, so I think we should conclude this and continue it over a glass of wine outside. I want to thank our audience, but primarily I would like to thank our speaker. And here on
oh, wow, so nice.
Thank you so much.
Oh, I appreciate it. Thank you so much. I really love this. Yeah, thank you.
All right, thank you so much.